This is a government. This is a government which has been legitimately formed. All right, that's step one. Second, para 166 says that the governor cannot assume to himself the aforesaid judicial power. For the governor, he has to treat these as part of the Shiv Sena, irrespective of what their internal dissension is.
And say.
Therefore, he cannot now say that this 34, the letter which two important things which the governor has not taken into account, which to my mind were extremely important. One, that insofar as the Congress and the NCP are concerned, there is absolutely no shaking up of there is no internal dissension in either the Congress or the NCP. Congress had 44 members, NCP had 53 members. This is a block of 97. There's absolutely no dissension in either Congress or the NCP. So in the 97 still continues to be a solid block. What is disturbed is, say, out of the 56 that the Shiv Sena had, 34 have expressed a...
Which brings it down to your lordship, sir.
So out of the second thing which the governor had to bear in mind is this, that as of this date, there is not even a suggestion that the Shiv Sena is going to team up with the BJP to form the government. So that's again a circumstance which is totally alien to his consideration. So he can't be oblivious of the fact that in a three-party coalition, the dissension has taken in one party out of the three. The other two are steadfastly support the coalition, and they are not by any means, sidekicks. They are almost at par. All the three are virtually at par, except the Congress, which was a little lower.
May I only make one
lower than the.
May I only make one request? Look, to examine the facts of the case, after my lord, I show the law. Your lordships have shown, but some of the paragraphs, some of the law is unfortunately not assisted.
2006.
Thereafter also, my lord, why the governor can take that step, even if NCP Congress bloc is not disturbed? I'll, my lord, answer that. In fact, the reports of the governor intended to forestall any voting and staking the claim to form the government. Well, this was a case of Lord 356. He sent a report that now dissolve the government. Yes.
The stark distinction, so far as Rameshwar is concerned, Rameshwar government was not formed. It was at the initial stage immediately after elections.
Correct.
Where there was no party who got the majority. Instead of waiting for somebody to form a majority, the governor asked for dissolution of the House.
356.
And the reason he has given is that if I spend more time to allow a coalition to be formed, they will cobble up a majority and thereby violate 10th schedule and then create a government. So court said the governor cannot assume that one of the political parties would go ahead, cobble up majority by coalition. This is a wrong inference that the governor has drawn. But as against Rameshwar Prasad's case, this is a case where the government is subsisting for more than 3.5 years. So that's the distinction between Rameshwar and ours. I'm just putting it to you.
Facts, yes, but the legal proposition which I would, my lord, place for your lordship's consideration may be the same. The consequence which would, the power of the governor or the exercise of power of the governor at the time of initial formation or subsequent shall have to be the same. That's my respectful submission. Please come to, my lord, now PDF page 520 at para 161. Because I, my lord, with profound respect, do not see any any reason to not read this ratio for exercise of power under 174 and 175 also. This was also the case where the Supreme Court said you should have called for the floor test. You could not have said that, they might incur disqualification. 161, my lord, if your lordships, my lord, can. We are not, your lordships gets that, my lord. We are not impressed with the argument based on a possible disqualification under the 10th schedule if the MLAs belonging to LJP party had supported the claim of so-and-so to form the government. At the stage, it was wholly extraneous to take into consideration that some of the members would incur disqualification if they supported a particular party against the professed stand of the political party to which they belong. The intricate question as to whether the case would fall within the permissible category of a merger or not could not have been taken into consideration, assuming that it did not fall in the permissible arena of merger and the MLAs would earn the risk of disqualification. It is for the MLAs or the appropriate functionary to decide and not the governor to assume disqualification and thereby prevent staking of the claim by recommending dissolution. My Lord, your Lordships are right. My Lord Justice Narasimha are right. Fact situation was 356. But why, my Lord, I am posing a question to myself. This ratio not apply when the governor decides to call for a floor test, which your Lordship said is the only test. My Lord, further, it is not necessary for us to examine for the present purpose para 4 of the 10th schedule dealing with merger and or deemed merger. In this view of the question sought to be raised, kindly see the last line. It could not have been gone into by the governor for recommending dissolution. My Lord, what fell from my Lord the Chief Justice would be, my Lord, if I put it in the context of this ratio, would be that the governor will have to first form an opinion that these people are working since 3 years. They have a reason to, they have shown the reason to the governor why they are parting ways after 3 years. But can they do it after 3 years? Would it not amount to a split? Would it not amount to disqualification under Chapter 10, Schedule 10? My Lord, kindly come to my Lord 162, my Lord. The provision of the 10th schedule dealing with defections, those of the RP Act dealing with corrupt practice, electoral offences and disqualification, etc., and are legal safeguards available for ensuring purity of public life in democracy. But insofar as the present case is concerned, this had no relevance at the stage when the dissolution of the assembly was recommended without existence of any material whatsoever. There was no material for the assumption that claim may be staked based on democratic principles, but based on manipulation by breaking political parties. Now kindly come to my Lord 164 and 165. It is true. Does your Lordship have that? It is true that, and kindly, my Lord, for my satisfaction, read it as 174, 175 instead of 356. It is true, as has been repeatedly opined in various reports and by various constitutional experts, that defections have been a bane of Indian democracy. But at the same time, it is to be remembered that defections have to be dealt with in the manner permissible in law. If the political party with the support of other political party or other MLAs stakes claim to form a government and satisfies the governor about its majority to form a stable government, the governor cannot refuse formation of the government and override the majority claim because of its subjective assessment that the majority was cobbled by illegal and unethical means. No such power has been vested with the governor. Such a power would be against the democratic principles of majority rule. The governor is not an autocratic political ombudsman. If such a power is vested in the governor and or the president, the consequences can be horrendous. The ground of maladministration by a state government enjoying majority is not available for invoking power under Article 356. The remedy for corruption or similar ills and evils lies elsewhere and not in Article 356(1). In the same vein, it has to be held that the power under the 10th schedule for defection lies with the Speaker of the House and not with the governor. The power exercised by the Speaker under the 10th schedule is of judicial nature, dealing with the question whether power of disqualification of members of the House vests exclusively within the House to the exclusion of the judiciary, which is in Britain was based on certain practices of the British legislature as far as India is concerned. My Lord, it has been said, I'll skip that. My Lord, please see 166. The governor cannot assume to himself the aforesaid judicial power and based on that assumption come to the conclusion that there would be violation of the 10th schedule and use it as a reason for recommending dissolution. Lord, he also cannot refuse floor test.
But look at what the consequence of these observations in the present cases. The governor,
I earnestly request your Lord.
But we are, since we are on those two paras, just those two paras. no such, the court says, the governor cannot refuse the formation of the government and override the majority because of his subjective assessment that the majority was cobbled by illegal and unethical means. Therefore, irrespective of what the governor feels or what somebody else feels about, the fact that in forming a government with the INC and the NCP, you gave up a pre-poll alliance, it is irrelevant to the governor. This is a government which has been legitimately formed. All right, that's step one. Second, para 166 says that the governor cannot assume to himself the aforesaid judicial power and based on that assumption come to the conclusion that there be a violation of the 10th schedule. So it was alien to the governor's mind that these 34 would have to be excluded from consideration because they have incurred a disqualification under the 10th schedule. For the governor, he has to treat these as part of the Shiv Sena, irrespective of what their internal differentiation is. Therefore, he cannot now say that these 34, the letter which these 34 have given me, is a ground for shaking the faith of the government or the trust of the government which they have. He has to take these 34 as forming a part of the Shiv Sena legislature party.
Now let me show.
And if they are a part of the Shiv Sena legislature party, where is there any ground to say that, well, there is now a change in the position of trust in the house? Prima facie, at least, for him.
Now, my lord, let me show the judgment of the High Court, which was dealt with by Bomai judgment. Your lordship's, my lord, very right concern, my lord, comes in the form of Mr. Sorabji's arguments, which was rejected, and your lordship in Bomai did not accept that rejection. Kindly, my lord, allow me to place, my lord, that my lord, in that context, the request was that give me floor test. Don't impose precedence rule. Let the 10th schedule play its role. If somebody votes against the will of the party, he will be disqualified. But don't take extreme step of 156. Take step under 174 and 175. That's what precisely the governor has done. And, my lord, a similar situation arose. And, my lord, now I will read your lordship's the judgment in Shivraj Singh Chauhan, where all this is considered. But before that, please come to para 7 of my propositions, my lord. There are more than one reasons, my lord. Why, my lord, this cannot be the argument of the petitioner, and I'll demonstrate, my lord, what is the flip side of this argument. If your lordship's, my lord, were to hold that governor cannot examine the inter se dispute or he waits till the speaker decides disqualification. What is the flip side? I must, my lord, assist your lordship with that flip side. Para 7. There is one more reason why governor cannot preempt the decision of the speaker at the stage of directing floor test, since it is possible that the original political party of the members of the house may condone the defiance of the whip as contemplated under para 2(1)(b) of the 10th schedule. Lord, kindly pause here for a minute. Lord, disqualification is not automatic. If I, as a member of legislative assembly of a particular party, vote in defiance of the whip, so there is a provision that the party may condone it within 15 days. So governor cannot say that I'll wait for 15 days when he is presented